So this is Michael Wynhausen, Lynn County Circuit Court Judge, Position 1 candidate, and we're starting our Q A session, so we hope people will check in and have some questions and go from there. So
yeah,
we got any background questions or?
Well, and just so everybody knows the voice that they're hearing, I am Wyatt King. I'm Michael Wynhausen's Facebook video coordinator, and so I'm going to be helping out by asking questions. I'll give a quick get in there. Hey, yeah, there's my mug. Okay, and so let's start off with just your elevator pitch. Who are you? Why are you going for judge? Why should people vote for you?
Well, I've been a prosecutor for over 22 years, and in that time I've developed obviously a particular interest in issues of public safety, and I recognize that over that period of time there are a lot of positive things that a person can do as a prosecutor, positive impact on the community. But as I've gone through my career, I've found more and more that I believe that the judges are in a position to even have a greater impact on the community in a good way. And so that's my primary reason for running for the position. I have the experience and the background, I have the courtroom experience, I have the experience with the criminal justice system, but I also have the connection to the community. And so I've lived in Lynn County for over 20 years now, and I have the support of the entire law enforcement community, including Sheriff Jim Yon, former Sheriff Bruce Riley, and former Sheriff Tim Muller. Frank Stevenson, the Chief of Police of Lebanon, has given me his endorsement, as well as all the police agencies in the county. And so I certainly appreciate that. But it's not just about law enforcement. I've got the support of community leaders like Andy Olson and Sherry Springer, our state representatives, as well as Will Tucker and John Lindsay, who are our county commissioners. And it's been overwhelming, the support that I have received from the people of Lynn County and a lot of the businesses in Lynn County. It's just been great, and I want to take an opportunity to give back. So.
For sure. So, have you ran for the judgeship before, and how many times have you thrown your hat in the ring, and how did that work?
Well, I don't even remember the first year I threw it in. I've actually applied with our governors, Kitzhaber and Brown, approximately about 5 times total. But I've only run for the office once previously, and that was in 2010. That was, I believe, when Glenn Basinger retired and left an open seat. There were 5 candidates who had filed for the position: Tom McHill, David Delsman, Arnold Poole, Paul Meadowbrook, and myself. And when the election came down, I was the second out of the 5 candidates in that race, and Tom McHill won that election, rightfully so. He had far more experience at the time than I did, and so that was exactly the right person to get it. He's been an outstanding judge. He's now our presiding judge, and I can't say enough good things about him. But by that same token, in this race, I've got the experience. My opponent has virtually no real experience. She graduated from law school in 2006, passed the bar a year later in 2007. I was admitted to the bar in May of that year, and worked at a number of jobs until in 2009 she left her legal aid position, which was actually practicing law, and went to work for the as an ALJ, I believe, and then let her license lapse essentially in 2010, voluntarily inactive. And so the work that she did after leaving legal aid was not practicing law. It was doing other things, and that's what she has done up to and even after she was appointed to the position by Kate Brown. She didn't have an active law license at the time, ended up having to get an emergency reinstatement from the Oregon State Bar. That occurred in November of last year, and then was finally reinstated to the bar officially by the Oregon Supreme Court in March of this year. And so she had not been practicing law from January of 2010 until her temporary reinstatement in November. So even if you were to consider all the time since she graduated law school, I still have twice as many years of legal experience that she does. And in reality, it's substantially more than that, almost 7 times as much.
Okay, so before we move on to talking about your background and how that's impacted you, if we could just really quick summarize your elevator pitch. So again, what are the big points of why people should vote for Michael Wynhausen?
Well, first and foremost, it's experience. As I said, I've got over 22 years of experience, and it's in criminal law, but it's courtroom experience, and that's really crucial. If you don't have courtroom experience, you're going to make mistakes. When you're a judge, you've got to run the courtroom. You've got to understand the rules of procedure. You've got to understand the rules of evidence. I have been practicing in court virtually every single day of my career, and I know these rules. I know the rules of evidence. I know the rules of procedure. And the reason it's so important is that if you have a case, and it can be civil or criminal, and you have someone who doesn't have that courtroom experience, then mistakes are going to be made. Evidence that should come in doesn't, evidence that shouldn't come in does, and it can essentially impact the outcome. So you have a person who should be getting compensation for injuries suffered, and they don't. You have a person who is charged with a crime, ends up being convicted, and they shouldn't. And so, these are some real issues in the case. And so that's the experience I bring, but it's not just the courtroom experience. It's my experience with Lynn County. As I said, I've done this for over 20 years, but 15 of those years were working for the Lynn County District Attorney's Office. That means 15 years of working with court staff, 15 years of working with the judges, 15 years of working with the attorneys in the area, the defense consortium, as well as seeing and interacting with attorneys who handle civil cases. So I have that experience as well. And in the context of the criminal law, not everybody needs to go to prison. There was a recent suggestion that I am somehow a hothead or I'm unreasonable, and that I ask for the maximum sentence for every first-time offender, and that's just patently false. The reality is, I've had 20 years to look at people's behavior. So when I get a case, I look at what did they do in this particular instance? What were the underlying facts of that particular case? How egregious were they? What were the circumstances? What kind of criminal history does this person have? Have they never been in trouble before? In which case, I can chalk this up to just making a mistake, a little bad judgment, maybe had too much to drink, whatever it may be. But I can look in that kind of a situation and say, look, this guy needs some supervision, needs to have some opportunities to get into treatment or whatever. But then you see the people who are chronic offenders. They commit crime after crime after crime. They need to be held to account. And it's the few people who are chronically committing crimes that commit the lion's share of the crime here in Lynn County. And it's those people that I have, over the years, I can identify those people based on their record, based on their behavior, and take the appropriate action. I do that now as a prosecutor, and would certainly do that going forward as your next Lynn County Circuit Court judge.
Awesome, thank you. And so we've had a couple of questions.
Okay.
First one is, can you clarify how your opponent was an administrative law judge but didn't have an active license to practice law?
Well, the fact of the matter is, an administrative law judge, although sounding quite impressive, is really just a bureaucratic appointee. A person doesn't even have to have a law degree, let alone an active license. So working as an administrative law judge is not, by definition, practicing law. If it were, then my opponent, Judge Stets Waters, would have been engaging in the illegal practice of law when she was an administrative law judge after she allowed her license to go inactive. And so, as I said, it sounds impressive, but basically anybody can be an administrative law judge.
Okay, thank you. And we have another question. Many people in our community have stated that as a DA you have been too hard on sentencing, and as a judge you will be also. Can you please explain the impact Measure 11 has had on discretion in sentencing?
So I will say this, and one of the recent forums I mentioned that issues surrounding our sentencing laws here in Oregon are probably the biggest problem with the criminal justice system in the state. And the reason for that is this. We have sentencing guidelines which have greatly hampered the authority of the judges. We had the passage of Oregon Revised Statute 137-635, which set aside certain serious crimes for determinate sentences for repeat offenders. And then of course we have Measure 11, which is mandatory minimum sentences for specific very serious person crimes. So we're talking about serious sexual assault, kidnappings, serious assaults, manslaughter, murder, things of that nature. And so they have these mandatory minimum sentences. The problem I have is this, every single case is different. It could be the same crime being committed, but the person committing it and the facts surrounding it are going to affect the outcome. So from my perspective, the best way to handle this is to let the judges, who are elected officials at the end of the day, make those decisions based on the information at hand. So based on a person's history, based on the nature of the crime, and then sentence within the bounds of the magnitude of the crime, whether it's a Class A felony, which has a maximum of up to 20 years in custody, or a Class C felony, which is up to 5 years. But the judges are in the best position to look at those facts and to make that determination, and it really isn't something, from my perspective, that should be done by the legislature, or have the legislature hand so much control over the prosecutors in terms of their charging decisions. So, it's an incredible responsibility to be sentencing people, and I would cite to an anecdote brought up by my opponent at one of the forums. She talked about a case that I wasn't personally involved in, but a case where she characterized it as a man was going to prison for stealing a coloring book. And that was really sort of half the facts involved in the case. But she basically laid out that the agreed upon 15-month sentence between the defense attorney and the prosecutor was unjust. Now the reality was this individual was a repeat offender, and also the crime that he was actually convicted of and sentenced on was robbery, was a robbery charge. So it was a theft in which he threatened the use of or actually used physical force to complete that crime. And so he had enough of a history that he was subject to property crime, repeat property offender statute. And my understanding is the sentence that was presumed under that scheme was somewhere in the neighborhood of 24 months. I'm not 100% positive of that, but the parties that were involved, the defense attorney and the prosecutor, agreed to what is referred to as a downward durational departure, reducing the length of the sentence. So all that aside, the problem that I had with what she had to say was, here she was the judge who makes the final decision in this scenario, saying that the 15 months that ended up happening to this guy was unjust, and yet she had the authority at that time to give him a probationary sentence. If she thought it was an unjust sentence, she had an obligation to impose a sentence that she thought was just, and she didn't do that. For the life of me, I don't understand why. If I am elected to be the Linn County Circuit Court Judge for Position 1, I'm going to seek justice just as I do as a prosecutor, and I'm going to seek a just sentence, and it's going to be dependent on the facts and circumstances of that particular case and the person's history.
So there's been a lot brought up between making sure that we're considering where the person who committed the crime came from, the influences that their upbringing had on leading them to commit the crime. There's a big focus on, of course, not sending anybody who was innocent to jail or being overly punitive. But we also need to think about protecting the community and making sure victims get justice. Those are very serious concerns to the people of Linn County. So how do you find that balance, and how do you best protect Linn County without disrespecting the rights of those who've been accused of committing crimes?
Well, first and foremost, we have certain principles under our criminal justice system, and right at the front of that is the presumption of innocence. So when someone is charged with a crime, they are presumed innocent unless and until they are proven guilty beyond a reasonable doubt or enter a plea to the charge. So that's the way we prevent people who are not guilty of crimes from being convicted. Once that has occurred, again, it's incumbent upon, I think, the prosecutor as well as the judge to look at the underlying facts. If I have someone, as I said, who has virtually no criminal history, and this looks like an aberrant behavior on their part, I'm not interested in throwing the book at them. This is a person who, in all likelihood, is going to change their ways just having gotten involved in the criminal justice system. But we'll certainly want to have them under some form of supervision and require them to go through some applicable treatment. If it was an alcohol-related incident, would want them to have an alcohol evaluation and comply with any treatment recommended. Same thing with drugs. If it was a domestic violence situation, we'd want to get them into our domestic violence court that we have here in Linn County and make sure that they get batterers intervention so that they can learn other tools in dealing in their relationships rather than going and subjecting people to violence. So those are things that can occur. On the other hand, if we have someone who has a lengthy criminal history, who continues to commit crime after crime, continues to rack up victim after victim, they need to be dealt with, in my opinion, harshly. They need to be addressed, and we need to make sure those kinds of people who've had opportunity after opportunity to change their ways be dealt with in an appropriate manner, and that will oftentimes mean going to prison. And the victims can't be lost in all this. Victims have rights, and they're so often forgotten, but we have people who are suffering property damage, physical harm, any number of things, and it's men, it's women, it's children, and we need to address those issues as well. And so that's my approach.
Okay, so let's talk about your background a little bit. What were some of your defining experiences, your favorite victories and your saddest defeats? What has shaped you in the justice system?
Well, I can talk about a few things. I remember when we're talking about victories, although somewhat Pyrrhic to a certain extent, I had a case when I was working in Benton County. A young woman, Robin Jensen, who worked at the Osborne Aquatic Center, was riding home from work. Her parents lived in the Lewisburg area, so she had a ways to go. She had to go by Crescent Valley High School to get home. She was struck by what I am certain was a drunk driver by the name of Amy Stack. She ran her down, didn't brake, didn't do anything, and then hid her vehicle in her garage, called her father, who was an attorney, who presumably suggested that she hide out for a few days, and then hired a lawyer and said, we may have the car that was involved. This car had a windshield that was pushed in. The victim's hair was caught in the glass. There's no way she didn't know what she had done. Unfortunately, because she had hidden out all those days, we could not make a case for driving under the influence of intoxicants, and therefore we couldn't make a case for manslaughter. And we ended up going forward with a charge of failure to perform the duties of a driver when a person is injured. We refer to it as hit and run felony. And we ended up getting a conviction and a upward departure sentence of more than what was presumed under the statute, but she only ended up serving about 2 years. And so that was both a victory, but also it was a little disheartening to see that justice wasn't done in that case, in my opinion. And I've had I had a recent case with a gentleman's not the right word, a person, a defendant who had engaged in sexual activity with his stepdaughter, a young lady that he had known for since she was 3 years old, and she was 13 when he did this to her. And we got a conviction in that case, and he was sentenced under Measure 11, received 100 months for rape in the first degree, and he certainly deserved that. And so, this is really gratifying work. It's why I enjoy doing what I do, because I'm able to right wrongs and to help crime victims. And so that's sort of my background.
Yeah. Based on the stories that you brought up, I can tell that you do have a lot of concern for the victims, and seeking justice for them must be a huge motivator in what you do. We had a question that ties in with that I wanted to ask. One of our comment questions was, can you tell us about any programs or agencies that you have been involved that supports victims in our communities? And to add to that and expand it, just what you've been able to do outside of your work as a prosecutor to help with victims and to help get them justice.
Well, first and foremost, and our office, our district attorney's office, has what's called the Victim Services Department. We have a separate office. So we have employees within our office who are specifically there to be contacts with the victims from our office, to make sure that they know when the court appearances are, when they need to be there, keep them apprised of what's going on in the case, get information from them regarding any sort of losses they may have suffered, any sort of issues that may be cropping up in terms of maybe a need for counseling, and we help facilitate that, actually utilizing state funds in many cases in order to get them that kind of help. In addition, I've been a member of the board for the ABC House, which is our child advocacy center. So this is a place where children who have been subjected to physical and sexual abuse as well as drug exposure are taken. They receive counseling, they receive medical examinations, and then oftentimes they'll have forensic interviews conducted at that location, either by forensic interviewers who are from the ABC House itself, or by specially trained law enforcement officers. And my work with victims has been recognized by state agencies. I have the endorsement by Steve Dole, who's the president of Crime Victims United. So there's a recognition of that in my work, and I get that support because I have been such an advocate for victims.
Thank you. Okay, so let's jump into the compare and contrasting between you and Faye Stetz-Waters just a little bit. One of the big things is that they tout her breadth of experience, but it's not experience in Lynn County Circuit Courts. And so if you can get into just a little bit the difference between direct experience within county courts and this kind of breadth of experience that she brings to the table, and why it's important that you have experience of how Lynn County works and how everything plays together.
Well, she has virtually no circuit court experience, but for the time that she actually got onto the bench after being appointed by Kate Brown. And so I think it's important first to look at that aspect of it, just the experience itself. There was an application process to get the appointment, and each of the people, including myself, had to fill out a form and actually sign it and attest to the facts therein. And one of the questions that's asked is, how many trials have you had in the last 5 years and in total in your career in any area of law? And when she presented her application, she had 0. She had never had a trial, according to her own statement, in any area of law during the course of her practice. Now, I've prosecuted over my 22 years literally thousands of cases, and I've tried hundreds. And so I have that kind of experience, and it's the courtroom experience that's so crucial. And more pointedly for Lynn County, you need to know the people that are involved, you need to know the procedures that are done, you need to know, because every courthouse is going to be a little bit different. Obviously they're all operating within the bounds of the law, but at the same time, every jurisdiction has a different way of doing things. And I've been working here in Lynn County for over 15 years, and so I understand the process, I understand the way they've set it up. And as a practitioner in Lynn County, I also see some things that when I look at them, I think, boy, I think that's something that maybe we can improve on. Whether it's our duty court, every Monday we have duty court all day long, and it's an incredible, it uses up a lot of time of the attorneys that could be spent doing other things. And I understand the court's going to have some issues as well, and there's reasons for why they do things, so I'm not criticizing. But at the same time, having come from the perspective of working in Lynn County, I've seen the things that work and some of the things that don't. Hopefully, when I get to be Lynn County Circuit Court Judge, I'll be able to try and fix some of those things going forward. And so that's another reason why it's so important.
So during the forums, you've brought up a couple of times pro tem judges when you're talking about Faye Stetz-Waters qualifications. What do you mean?
So there's a process by which, and it's not one that I can do because I actually am a member of the executive branch, and so there's a separation of powers issue, but an attorney who is in private practice and wants to get some exposure to judicial experience can apply to the Oregon Supreme Court to become a judge pro tempore, or a temporary judge. And the Supreme Court has set up criteria for that. minimum criteria to even apply for the position. And those criteria include at least 3 years of legal practice immediately preceding the application, and also a minimum of 2 years of litigation experience. So the Supreme Court recognizes the importance of litigation experience, and this is to be a temporary judge. So these judges are asked to fill in when there's a judicial conference and all the other judges are gone, because there are certain things that the court has to do every day. They can't close for the day. They've got to get things done. And so they have them come in to handle these sorts of relatively simple, straightforward judicial processes. And so you need to have that 3 years minimum immediately prior to the application and 2 years of litigation experience. And the reality is, as she sits on the bench today, on our circuit court bench, Faye Stetzwaters would not qualify to be a pro tem judge. She doesn't have 3 years of practicing law immediately preceding that application, nor does she have 2 years of litigation experience. In fact, based on her own statements, she has virtually no litigation experience.
So when she was appointed to be a permanent judge, she did not have the qualifications to be a temporary judge.
That is correct, nor was she actually, did she actually have an active bar license at the time. She had to have an emergency reinstatement about 20 days after her appointment.
And so how long had she been inactive before she got that rush reactivation?
It was January 30th of 2010 was the date that her license went inactive. That's based on records obtained from the Oregon State Bar, and she wasn't reinstated, even on a temporary basis, until November. Let me confirm this. I don't want to misstate the facts at all, but it was November 9th of last year was when she was temporarily reinstated, and then March 7th of this year was when she was formally reinstated by the Supreme Court.
So for most attorneys that went inactive for that length of time and then had to be reactivated, what would the standard process be, and how long would it typically take them?
Well, I can't speak for the standard process. There are rules by the Oregon State Bar that govern this, and they need to make a determination that the person is of good character, and I have no questions about that with Faye Stetzwaters. I have no reason to think that she doesn't have a good character. But they also have to make a finding that they are capable of doing the job. And within the rules, someone who has been voluntarily inactive for a period of 5 years or more can be required to retake the bar exam. And of course, during that period of inactivity, she's also not getting her continuing legal education credits. And so for that span of time is approximately, she would have had 3 reporting periods at 45 hours per year, so that's 135 hours of continuing legal education that she wasn't getting because she wasn't required to. Mm-hmm. And so, I don't know what process was followed in this instance. The rules don't require retaking the bar. They don't require catching up on CLEs, but they certainly, under that set of circumstances, can be required. And so the emergency reinstatement was a little bit surprising.
Okay. We have a long and great question, actually from another judicial candidate, so you know it's going to be a great one. Rachel Kitson McQuadish asked, when providing a plea offer as a prosecutor or sentencing a defendant as a judge, why is it important to know the difference between someone that had a bad day and someone who is a career criminal? In other words, how important is it to know when the defendant is sincerely remorseful and needs some grace, or is feeding the judge a story, we'll say?
Again, you have to look at the person's history, and you have to look at the nature of the crime. There are some crimes that someone who doesn't have a history, but they end up committing it, it's so serious that it needs to be addressed in a serious manner. But when you look at the facts and circumstances of the crime and look at the history, if they're in front of the court, let's say for dealing drugs, heroin or methamphetamine or something like that, and I look at their history and I see, conviction for possession, conviction for delivery, possession, delivery, I see 5, 6, 7 convictions or more for those offenses, I know as a prosecutor, and I would know also, and the judges know as well, that every single time this person was convicted of these offenses, and these are just the ones they're convicted of and caught doing, they were required to go through a treatment program. So when I'm prosecuting a case and I have a defendant in that posture who says, "Oh, I'm just trying to feed my habit, and I've never had a chance to get treatment," I know that that's a lie, because I know they've had the opportunity to get treatment, and they've chosen not to engage in that treatment or follow through. And so when I see someone like that, I have very little sympathy for them. On the other hand, if I see someone who has no criminal history and is dealing in small quantities, and it's pretty evident that they're doing it just to feed a habit, that's the kind of person that I'm going to say, this person needs to go on supervision, this person needs to be evaluated by an appropriate substance abuse evaluator and given a treatment program, and give them an opportunity to address that treatment program. And typically, because it's a felony, they're going to have a probation officer, so someone who's kind of keeping on them about it. And so that's really, that's kind of a specific example of the difference between the two.
So we had another question that I believe really ties into this well. We have some chronically mentally ill residents in our county. What kind of resources are available for them, and how can judges help them?
This is actually a really sad situation. We do have a number of people, and I can think of a few by name, I won't mention the names, but who are genuinely mentally ill. Some of these people have actually asked, please, can you take me into custody? Can you send me to prison? Because there's that structure there. But what happens is we get these people in, particularly in some of the changes in the drug laws, reducing them to misdemeanors. So we have this person who comes in on a misdemeanor offense, who is really mentally ill. And once they're outside on their own, if they're not being watched or they're not in a secure facility, they end up getting off of their meds, which are genuinely helping them, and they end up substituting them with alcohol or methamphetamine or heroin or a combination of those things, and they end up decompensating and then engaging in the same kind of conduct. And a lot of times it's shoplifting or trespassing or breaking in places, and sometimes it gets very serious, but it's a real difficult problem because the mentally ill really shouldn't be addressed in the criminal justice system, and unfortunately we just don't have the resources available. And again, you still have victims in those cases. As sympathetic as these defendants are, you still have victims who are suffering as a result of their conduct. So it's a really, really difficult problem, and one that really needs to be addressed at the legislative level. But we need to shift some funding towards mental health treatment and mental health facilities so that we can get these people on the right track. Because when they're stable and they're on their meds, they do okay, and they don't commit crimes. But it's so hard to keep them together a lot of the time. So it's a really unfortunate situation, and unfortunately it's been dumped onto the criminal justice system to address it.
With your hands tied a lot of times.
Well, yes. If there was a way, for instance, for us to be able to utilize the civil commitment process more readily, and take them off of that criminal law track and push them to a civil commitment kind of track. Again, it's still a resource issue, but I think that would be incredibly helpful.
So, to dive into this just a little bit more and to bring up some of the technical details and complexities of these situations so our listeners and viewers can see how difficult it is to navigate all of these different processes, a lot of people have somebody that they're concerned about, somebody who is acting weird, is doing some petty crimes, and they think that, hey, this person might hurt me. But when they go to get help, to get a restraining order, or hoping that one of these smaller crimes is going to turn into some jail time, a lot of time they don't have those protective resources available. Why is that? Why is it so tough to take care of somebody before they've committed the crime? Why does it have to be reactionary?
Well, that's part of our system. Our system is sort of built on that. And again, we get back to innocent unless and until they've been proven guilty, and you certainly have to commit some offense even to get into that situation. Now, oftentimes there are people who are in that kind of situation where there is a restraining order in place, or they have some other probation that they're on another matter. And so there's some level of influence that can be, or a level of action that can be taken either through the parole and probation department, or if there's a violation of a restraining order, to take that action seriously. And again, it comes down to looking at the situation, looking at the underlying facts, looking at the person's history. As a prosecutor, if I see someone coming in on a contempt charge, which is the offense that would be charged in an instance where someone has violated a restraining order by breaking the contact kind of situation, or calling the person up or whatever it may be, I want to look at those underlying facts, and I'm going to make a recommendation to the court. If this is someone who's basically stalking this victim, I have some real concerns there, particularly if there's violence involved or substance abuse, and I'm going to want to have that person held in custody while that matter is pending, and then address it in any form of supervision that may occur. On the other hand, we have a lot of cases where the person who originally got the restraining order is actually inviting the person to come over, and they're living with them, and then something goes sideways, and then they decide to call the police and report the person as violating the restraining order. In situations like that, I'm not nearly as concerned about that individual when they violate the restraining order. Obviously, it's important to hold them to account, make sure they follow those orders, but at the same time, that's a completely different situation than the individual who appears to be unstable, appears to be prone to violence, and if we don't take a hard line with those people, we may end up with some more serious offense down the road, an assault, God forbid, a murder or a murder-suicide or something along those lines. So, and that's something you develop through experience, seeing these cases day in, day out.
Okay, thank you. And so we had another question on people with mental illnesses. What do you think about the new law on taking guns from mentally ill through no due process?
I think, and let me start by saying there is a process that's set up. I cannot, as a judicial candidate or even as a judge, prejudge any given situation. The law is in place. There is a procedure that goes along with it, and there is a process that is to be followed. And so, as a general rule, that is the way it would be handled pursuant to that statute. That said, depending on the circumstances, and it would vary from case to case, if there were a violation of the Constitution, specifically in the area of due process, that was clear in that procedure, then as applied to that individual situation, it would be an unconstitutional situation. But again, it's case by case. I can't speculate one way or the other, and you have to look at the facts and circumstances to make those kinds of determinations. But the reality is, the law is passed by the legislature or the people, and judges are duty-bound to follow it unless and until there is a showing that it runs afoul of either the state or federal constitution, in which case that law must fall to that higher authority.
So what is an example of a easy to make mistake in the courtroom where a judge that wasn't as experienced might disallow some evidence that should have been brought in, or messes up a case by not following the standard and then having to toss out evidence that really should have been applied?
Well, one of the things that's fundamentally misunderstood by many practitioners of law is the rule regarding hearsay. Hearsay is defined as an out-of-court statement by a third party being offered for the truth of the matter asserted in the statement. So as a simple example, let's say there's a car accident and there are a number of different witnesses, and there's a witness who isn't testifying in the case but told another person or told a police officer, this is what happened. That would be, and you're offering that for the truth of the matter asserted in the statement, that would be hearsay. But there are tons of exceptions and definitively things that aren't hearsay. An example would be statements by a criminal defendant or a party opponent. Any statement made by a party opponent in a given case is not hearsay. And so a very straightforward and fundamental mistake would be to say, well, you can't bring up that party opponent's statements because it's hearsay. And oftentimes that involves a person's confession, a person's statement which creates culpability on their part, and so to prevent that evidence from coming in would be very problematic. And so that would be a simple example of a mistake that could be made, just not understanding the rules of evidence. And the only way you do it is by practicing law and doing it in the courtroom. And if you haven't been doing that, you're just not going to be able to understand and effectively apply the rules of evidence and procedure.
So with your 22 plus years of experience as a prosecutor, you've been in and out of courts, and so you've seen tricks that have been pulled, you've seen gaps in defenses or prosecutions, you've seen a lot. Now let's compare that to Faye Stetzwaters. Her big things that she includes in experience in these relevant areas is her time as administrative law judge and also her time as a parole board hearings officer. Can you explain a little bit what those roles do and contrast that to her experience, well, your experience as a prosecutor, and how they'd apply in the Lynn County Circuit Court?
Well, as I said before, an administrative law judge is not a practitioner of the law. An administrative law judge is someone who is hired. So for instance, a DMV hearing. So your license gets suspended, you have the right to go to before an ALJ or administrative law judge for your DMV hearing to determine whether or not your license should be suspended. That is a person who doesn't have to have a license to practice law, an active license to practice law. That person doesn't have to have a law degree. So it's simply not practicing law. It's an administrative process. And so you just follow the flow chart and you make your decisions. Now there's some evidence that's taken. The rules are different. They aren't the same as in a regular court scenario. And then with the parole board, I'm not wholly familiar with it. It's my understanding it's people who review individuals who are incarcerated in our prisons for possible early release from the sentences that were originally imposed by the judge. And so I have to assume that they look at the person's history, they look at the nature of the crime for which they are currently in prison, and they look at the person's behavior while they've been in prison in order to make a determination as to whether or not they should be released. Now, after hearing the very criminal sympathetic posture of Faye Stetzwaters at the Mennonite Village Forum, I have to assume that those are things that she was very sympathetic of, and probably handed down a lot of paroles, or at least was a party to that. I don't know that. I'm just speculating based on the information at hand. You have to have that. I think you have to have that hands-on experience. I think as a criminal defense attorney or as a criminal prosecutor to really get a good feel for what these people are doing and seeing the aftermath of what they do. Because as a defense attorney or as a prosecutor, you're in there with the victim. You're in there seeing the impact that this defendant has had on this victim. And if you're sitting on the parole board, I have to assume, I don't know this to be true, but you're just looking at everything from the defendant's perspective, and the victim gets lost in all that. And so that's certainly not something that would occur with me.
Okay. So we're about to need to wrap up here, but I just wanted to ask one more question before we get into the wrap up. So it's pretty clear that when it comes to criminal prosecution, criminal cases, you have far more experience than Faye Stetzwaters. When it comes to interpreting bureaucratic rules, civil cases, disputes of non-criminal nature, she might have the edge on you. And so when it comes down to what Lynn County Court deals with, how important and how much work is the criminal side versus the civil side?
Well, I'll answer that in a couple ways. Number one, the criminal cases take up the lion's share of the docket. So they occupy most of the work, or more of the work, that the courts are doing. So in that respect, it's going to be important because that's what is mostly going on. But that aside, the fact of the matter is lawyers are like doctors insofar as to be competent in whatever area they are practicing, they need to specialize. So 1, 2, or 3 different things. In my career, I've done work not only as a criminal prosecutor, but I've done work in juvenile dependency cases. So this is cases where there's been abuse of some kind to the point where the Department of Human Services has taken custody of these children from their parents. I've handled those sorts of cases. I've handled juvenile delinquency cases, which are quasi-criminal. I mean, they're similar, but this is when underage individuals are committing crimes. And so I've worked as a juvenile delinquency prosecutor. In addition to that, I've also done civil work in the area of mental health and civil commitments. It's the responsibility of the DA in some cases to handle those cases on behalf of the state, where you are basically on the side of proving that this person should be committed under the standards that are set by that type of case. And then I've also done cases involving support enforcement, so child support enforcement, which is a civil, can become criminal, but it's sort of a civil situation. So I've done some work in those areas, but the reality is that anyone who ends up taking the bench, there's going to be a learning curve of some sort. And the reason that it's so important that a person has that litigation experience is because that goes through all areas of law. If you're having a proceeding, those rules and procedures apply to all cases, and they're different from civil to criminal in certain ways, but that's really the crux of it, because you're running the courtroom. You're not presenting the case, you're not presenting a defense, you're not a participant in the litigation. You are overseeing that process, and you're overseeing the taking of evidence, you're overseeing those issues, and then you're applying the law as it is necessary in making your rulings throughout the case to manage that process. And so it's really that courtroom experience that's going to be key. Will there be a learning curve for me? Absolutely. And I'm fully prepared to do that.
So just one more time to talk about the experience differences between you and Faye Stetz Waters. Again, so she could not have even been put in as a temporary circuit court judge, but was put in as a permanent judge.
Yes, she was appointed by Governor Kate Brown to be a Lynn County Circuit Court judge.
Okay. Well, we're running out of time here, so we better just switch over to the wrap-up. And so again, for anybody who tuned in late, or just as a refresher, because we've been doing this for almost 50 minutes now, who is Michael Wynhausen? Why should we vote for Michael Wynhausen?
Two things. First and foremost, my experience. I've spent, again, over 22 years working in the court system, and over 15 of those years have been spent here in Lynn County. But in addition to that, it's my support and connection in this community, in the Lynn County community. I've lived here since 1997, and I've worked in the Lynn County Courthouse and have been interacting with the members of the Lynn County legal community for over 15 years. And I have the support from Lynn County, and this is really, I think, one of the more crucial things that hasn't gotten a lot of attention. Virtually all of my support has come from individuals, from community leaders, from the law enforcement community, and from local businesses. So that's the endorsements that I've received, the support I've received from folks who help us out with the campaign, put up signs, make campaign donations, and then businesses who've done the same. I am supported by the people of Lynn County. By contrast, my opponent received virtually all of her support, not all of it, but most of it, from outside the county. Individuals who live in Multnomah County, in Marion County, in Benton County. That's where her support is coming from. In fact, there was recently an op-ed piece in the Albany Democrat Herald where 3 Kate Brown appointees, one from Polk County, and these are judges, one from Polk County, one from Multnomah County, and one from Deschutes County, attacked me in a political op-ed as if they have any understanding of what goes on in Lynn County, and suggested that I wasn't fair-minded. And so it's this kind of thing that's been going on. So all the support is coming from outside of Lynn County. And really it comes down to this from my perspective, which is the people of Lynn County should be choosing their judges. It shouldn't be Kate Brown. It shouldn't be people from Benton County or Marion County or Multnomah County or California, where all the support is coming from. It should be Lynn County. And so I am asking you, the voters of Lynn County, for your vote and for your support. And I'm asking that you support my campaign for Lynn County Circuit Court Judge. So thank you very much for taking the time to listen, and we'll see how it shakes out on the 6th of November.
Okay. Thanks for watching, everybody.